We're going to be discussing my favorite subject, which is bank certificates. At, at 4 o'clock on a Thursday evening, you get a frantic call from your client, the owner, and the owner is telling you he just got a message from the bank that the closing schedule for tomorrow morning, Friday morning at 9 o'clock, is not going to go through unless they have in their hand an executed bank certificate signed by the architect, which is known in the trade as an architect certification, which describes certain things that the architect is certifying to, and it has to be signed, sealed, and delivered so that the closing can take place. Most, if not all, of the AIA documents contain language which states that the contract that is being entered into between the owner and the architect is limited to those two parties. There are no third-party beneficiaries involved in the standard AIA documents. If there is a third-party beneficiary, it's specifically pointed out. The bank is not a third-party beneficiary to the owner-architect agreement that was executed on this particular
But that's only
situation.
the standard AIA language.
That is
A lot
correct.
of developers have language in their contracts that say lenders are third-party beneficiaries. What do you do about that?
Well, you have to be aware of the fact that if the lender is a third-party beneficiary of this contract, they do have some ability to determine what it is that you're going to be signing. They have more than just a passing interest in your owner-architect agreement, since they're the beneficiary of it, especially if it's going to be assigned to the bank upon your default, for instance, under an assignment provision.
You mean the owner's default?
If the owner's default.
This-
If the borrower, the owner, defaults on the owner-architect agreement, it will then be assigned to the bank.
So this really only kicks in and is important if the owner defaults and the bank winds up taking over the project. Then they want to have certain rights and remedies and
Well,
assurances.
no, it's
and
more
things.
if they're a third-party beneficiary, they're going to have a little more oomph to demand that the architect certificate they're asking for. They have some vested interest in having you sign something here.
So if
you're going to be breaching the bank's beneficial interest in the project if you refuse to sign something that is reasonable.
So let's talk about the situation where you've just got a standard AIA owner-architect agreement, and you've got that language in there that says that the any certificates like this have to be provided to the architect 14 days prior to signing, so that the architect can review it.
Right. That's a very reasonable provision within an owner-architect agreement, and it should be in every agreement.
Right. What,
It should be even be in a letter agreement. However, most architects, make their letter agreements.
So why
warm
does
and
the
fuzzy.
architect need all this time? I mean, isn't the bank just being reasonable and having the architect certify that the plans are meet the code and things like that? Things that are very reasonable.
That sounds like a reasonable approach, and if it's written in a reasonable fashion, it's acceptable. If the bank is asking for the architect's opinion that what has been constructed conforms to the codes and the rules and regulations governing the construction, that's a reasonable statement. If the bank is asking the architect to certify that the entire construction is in complete conformance with any and all codes, ordinances, rules, regulations, and so forth, that's unreasonable.
So-
If the architect can water it down and say that to the best of the architect's knowledge, information, and belief, it conforms with those items, that's acceptable.
So I've seen certificates that ask the architect to certify that the construction conforms to codes and regulations and so on. But the architect's plans have to conform to those codes. And so if the architect's plans have to conform to the codes, why doesn't the construction automatically conform to the codes?
Because the architect has no control over the contractor, and the contractor can build something that's hidden from the architect's view that which may be defective ultimately and cause the owner and a huge problem to the point where the owner might actually drop out of the picture. Or let's say the owner defaults on the payment to the bank. The bank then takes over the project and or the forecloses on the mortgage on the project. The bank wants to protect its interest in the project, its money that it's loaning the borrower. So the bank wants to have some assurances from the architect that things are right and proper. For instance, even though the owner-architect agreement would call for the owner to provide certain bits and pieces of information, such as a survey, which is accurate and complete, geotechnical report, which should be prepared by a geotechnical engineer and be accurate and complete. Other items that the utilities leading to the project site are adequate for the project, and so forth. What the bank does is it takes what is normally a normal owner-architect relationship and switches it around so that all of the protections that the architect has included in its owner-architect agreement are sort of set aside, and the bank is asking for things that are overly broad and beyond and outside the limits of the agreement, such as they're going to ask the architect to guarantee that the survey is complete and accurate. That's ridiculous because the architect has no contractual relationship with the surveyor, nor should the architect be reviewing owner-provided information for accuracy and completeness. That's specifically excluded in the owner-architect agreement. Same thing with the geotechnical report. How does the architect know that the geotechnical report is accurate unless he shoots and analyzes the soil conditions himself, which negates the use of a geotechnical engineer? And architects aren't really trained to do that.
Well,
That's something the owner should be
But
providing.
from the bank's viewpoint, the architect is sort of the master builder here, and he knows everything about the
I want to
project.
remind you that in most situations, the bank is not a third-party beneficiary of the owner-architect agreement. The bank has no contractual relationship with you, the architect, in any way, shape, or form. And you don't have to take direction or sign certifications that are well beyond your knowledge and guarantee things that are unreasonable. So the bank, first of all, the owner has breached the agreement by not providing you with 14-day time period, if you're using an AIA contract, during which time you can review this document with your attorney and decide whether you want to sign it, have your architect execute it or not, or whether you want to execute it or not. So you need time to react.
So what do you do? Okay, so let's say the 14 days.
You don't.
Let's say you get this thing within 14 days,
Right.
and you take a look at it, and there's some things that sound suspicious. What do?
You edit the language of the bank and the bank's attorneys so that it's restricted to those things that you've contracted to do with the owner, and you avoid guarantees because you'll negate your insurance coverage if you guarantee certain things.
So should you send it to your insurance guy?
You should send it to the insurance guy as well, the insurance reviewer.
And your attorney?
And your attorney, right.
Okay.
And your attorney will prepare language that is suitable. At the very least, if you decide to do this yourself, which I think is highly risky, you should review everything to the best of your knowledge, information, and belief. And you better stick to what it was that you contracted to do and just delete everything else. Don't be sucked into signing something that the bank is insisting you sign on. Remember, don't forget, you have no contractual obligation to do anything with the bank. The bank is the owner's problem, not yours.
So if you just sign this thing without reviewing it, and the owner later defaults and the bank takes it over,
And the bank relies on your certification.
so
That's a
they could
big
sue you.
problem. Absolutely.
So that's a big risk.
That's a huge risk. It's a risk that is not worth you taking.